Joining me now is Thom Hartmann. He's the #1 liberal talk radio host in the country. He's the author of the Hidden History series. He did the Hidden History of Guns and the Second Amendment recently. And now he's got the Hidden History of the Supreme Court and the Betrayal of America. Sounds strong, I like it. Thom, welcome back to the Young Turks.
Hey, Cenk, it's great to be here with you.
Always good to talk to you, brother. All right, so it's such a big topic. Let's start with something that's in the title, betrayal. So how do we get betrayed?
Well, the beginning of the betrayal was the seizure of power that most of the founders didn't anticipate or believe the Supreme Court could pull off in 1803 in the Marbury decision. Prior to that, the Supreme Court was basically the court of last resort. Ultimately, if you had a dispute with somebody had, some court had to have the final say. Your neighbor's dog eats your chicken, and you sue him, and you win or lose in the local court, and one of you appeals, and it goes to the appeals court, and to the state courts, and the federal courts, and ultimately it has to stop somewhere. And the Supreme Court was to be the court of final appeals, in addition to the court that would adjudicate disputes between the United States and other countries and between the individual states. In 1803, in the Marbury decision, John Marshall, the Chief Justice, wrote the decision and essentially said, we get to decide, because we're interpreting the law, the supreme law of the land is the Constitution, and so we get to decide what the Constitution means, but not just that. We get to be able to strike down laws that we think are in violation of the Constitution. And then in several subsequent decisions, the court went on to say, we can not only strike down laws, we can even write laws. This happened in 1803 when Thomas Jefferson was president, and Jefferson responded by saying, this opinion, which gives the judges the right to decide what laws are constitutional and what not only for themselves and their own sphere of action, but for the legislature and executive also in their spheres, would make the judiciary a despotic branch. If this Marbury opinion be sound, then indeed is our Constitution a complete felo de se, which is Latin for a suicide pact. He said the Constitution on this hypothesis is a mere thing of wax in the hands of the judiciary. So that's where it began. The two big decisions that involved judicial review were the Marbury case in 1803, and it blew up in Marshall's face so badly, he basically never went back. And then the second big decision, there were a few small ones in that era, but the second big decision was 1856, when Roger Taney, who was the Chief Justice of the U.S. Supreme Court, thought that he would finally solve the slavery problem in his Dred Scott decision, which led us right to the Civil War. Following Reconstruction and the collapse of civility, shall we say, the collapse of the post-Lincoln era, we saw the Supreme Court begin to use, particularly in the 1880s, use judicial review much more aggressively. I mean, you're an attorney, you know a lot of this history as well as I do, right. And probably much better than I do in some regards.
Well, I doubt that, but thank you. So, Thom, but let's talk about some of the interesting ramifications of that. So if the Supreme Court can't review what is constitutional, well, then what do we do with that, right? So what if the executive branch was to say, you know what, I'm going to round up all the newspaper reporters who are critical of me in that wild hypothetical, right? Which unfortunately these days is somewhat possible. Well, who would get to declare it unconstitutional? And if they didn't, does it stand? Well, how would that get, if you will, adjudicated?
Right. George Mason wrote a long letter to Thomas Jefferson basically asking that same question after the Marbury decision. And this has been a matter of discussion during the writing of the Constitution in Philadelphia in the summer of 1787. And in all ratifying conventions, virtually every single one had some debate about the Supreme Court. And if you go back and read the three Federalist newspaper articles at the beginning by Hamilton and Madison. Oh, these are all by Hamilton, actually, about the court. He said that the Supreme Court would be the least likely to offend. It has neither the power of the purse as the Congress does, nor the power of the sword as the executive does. But when George Mason asked Thomas Jefferson about that, Jefferson answered very simply. He said, the people themselves. In fact, the dean of the Stanford Law School, whose name is escaping me right at the moment, but it'll probably come to me. Anyhow, he wrote a book called The People Themselves, arguing against judicial review. This is back 15, 20 years ago. And so Mason said, well, what the hell does that mean? And Jefferson said that, we have to trust the people. We have to trust the mass of the people. Congress is elected every 2 years. Every single member of the House of Representatives is up for re-election. If a Congress was to go nuts, if an executive, the president, was to go nuts, these are elected positions. And if you have any faith at all in democracy, the core element of democracy in a republic is the ability to re-regulate, to stabilize, to upright the ship when it starts to list or tilt. And if you don't leave that power with the people, you have essentially converted your form of government from a republic to a monarchy. And the monarchs are now, a bunch of people sitting in Washington, D.C. wearing black robes calling themselves Supreme Court justices.
That's interesting. Look, it's a compelling, fascinating argument. On the other hand, if you then, as president, said, okay, if there is no Supreme Court that could check whether I'm constitutional or not, why don't I just cancel elections?
Right. Well, you would have a revolt. I mean, again, you think Shays' rebellion was a big deal? Yeah, wait until that happens.
Although really with Democrats these days, they would probably immediately surrender. But anyway,
I really don't, and I don't think Republicans would either. We've had presidents who've done some pretty outrageous stuff in history, and there has been pushback, but very little like what we're seeing now. And your questions, your logical point here in the era of Trump is probably something that Jefferson didn't envision, because he was, the impeachment clause was clearly written, and everybody understood at the time that the impeachment clause was not for crimes. High crimes, if you go back and read, look at Black's Law Dictionary back in the 1700s, high crimes were defined as the abuse of office. High crimes were when people were exploiting their office for their own benefit, for power, or more commonly for wealth. That was the definition of high crimes. So, I mean, the founders would have impeached this guy Trump within seconds, or minutes, or hours, days. The fact that it hasn't happened is a failure of our system. But here's where it gets even scarier, Cenk. What if Trump says, "Okay, I'm going to call off the elections"? The Congress tries to fight it. It goes to the Supreme Court, and the Supreme Court says, "Well, we're in an emergency, and an emergency is envisioned by the Constitution, and the president has legally declared a state of emergency. So, cool. We'll wait another 4 or 5 years for an election." I mean, that's as conceivable as the idea that Trump would try to cancel the elections, which takes us back to Jefferson's point. I mean, that's not the essence of the whole book, and where it gets really interesting is I was going through the papers of the Reagan administration, during the 1980s, when there was this lawyer that Ronald Reagan had hired, or had been hired. Actually, Ed Mason hired him. He worked in the Reagan administration, and his job was he had been given a very specific assignment. The Republicans and Reagan wanted to roll back 2 Supreme Court decisions. They wanted to roll back the 1973 Roe v. Wade decision, and they wanted to roll back the 1954 Brown versus Board of Education decision. Both were very unpopular with Republicans. They wanted to go back to a time of segregation, legal segregation, and they wanted to go back to a time when men controlled the reproductive rights of women, period, full stop. So they hired this lawyer, a young up-and-coming conservative lawyer, and said, "Figure out how to do this." He spent a year and a half on this thing. He wrote about a 45-page memo. I found a copy of it. I doubt most Americans even know this memo exists. And in it, he starts with the Constitutional Convention, works all the way up to 1984, 85, whatever year it was he was doing this, finds multiple examples where Congress has used its Article 3, Section 2 power. In Article 3, Section 2 of the Constitution explicitly says Congress may regulate, in fact, shall regulate the court and determine exceptions to what the court can rule on. And so his prescription was that Congress and the if the Republicans could get enough of a majority, that they should simply pass a law saying that Brown v. Board was no longer operational. We're going to go back to Plessy versus Ferguson. We're going to go back to separate but equal. And that the 1973 decision in Roe v. Wade was no longer operational, and we were simply going to ban all abortion nationwide. And if the Democrats don't like it, tough luck, because we're going to write into these two laws that Congress is using its Article 3, Section 2 powers specifically to stop the Supreme Court from using judicial review. That lawyer went on to have a storied career. His name is John Roberts, and he's now the Chief Justice of the U.S. Supreme Court.
So look, you make a really great point about what if the court said, yeah, you can cancel elections. That is constitutional. And then if there's nothing above them, well, then that's fascinating and troublesome. On the other hand, you mentioned Roe versus Wade there, but if it was true that there was,
well, if I can, Cenk, if the Supreme Court said, okay, cool, no elections, then it goes to the John Roberts solution. Congress convenes, the House of Representatives, and passes legislation that says, no, there will be an election, and the Supreme Court may not rule on it. Because in Article 3, Section 2, it says that we have the power to determine what the court can rule on and can't rule on. If that could get through the House and Senate, and if there was enough popular sentiment for it, the court doesn't have to respond to popular sentiment. They're in there for life. But the elected branches, the House and Senate, have to. And if that got through, and they could override a veto with a large enough proportion that they could override a veto, they could force the elections back. Pardon my interrupting.
Yeah, that's okay. But you also mentioned Roe versus Wade there. Well, if there was no judicial review of what's constitutional, then you wouldn't have Roe v. Wade, right?
Well, arguably. I mean, it would depend on how Roe v. Wade was determined. The case of Roe v. Wade was based basically on a woman's right to privacy, on the 4th Amendment, on the 10th Amendment, on the 14th Amendment.
So it strikes down laws, state laws, and said they are unconstitutional because they're violating these rights.
There are other ways that they could have gotten to that. Where Roe v. Wade is problematic, and liberals need to understand this and accept this, or even or at least have a conversation about it, is that in Roe v. Wade, and then subsequently in Planned Parenthood v. Casey, the Supreme Court basically wrote law. They created law out of whole cloth. They said there's 3 trimesters. Each trimester has a different set of rules about when you can and can't get an abortion. I mean, most of that was out of Casey, but Roe v. Wade set it up. And there's nowhere in the Constitution that the Supreme Court has given that authority. This was the objection that the Reagan folks and John Roberts had, not just to Roe v. Wade, but also to Brown v. Board. And you could make that same argument against Plessy versus Ferguson and against Dred Scott, and probably a half a dozen other major Supreme Court cases. And we have not ever, outside of conservative intellectual circles, I mean, what's her name? The conservative woman who died just a few years ago. Anyhow, she wrote an extraordinary book about this. It's called The Supremes, about the court writing legislation. But liberals haven't engaged with this, and I raised that issue in here as well. In fact, there are a number of people I talked with. I believe it was one of the top people in Planned Parenthood. It might have been another one of the anti-abortion groups, and pointed out that in 1973. This was 12 years after the birth control pill was legalized. It was 5 years after the birth control had hit, a major threshold. I think it was 45 or 50% of women in America were using it or planned to use it. The women's liberation movement was really rolling along. Women were coming into the workplace. Individual states, one at a time, were starting to visit their aunts. Probably within a decade, you would have had what you have right now, which is legal abortion nationwide. But you wouldn't have had a persistent, angry anti-abortion movement that felt like this didn't go through an appropriate legislative process.
Yeah, look, I've said this a long time to some annoyance of our audience. I don't think Roe v. Wade was decided correctly. I think it was a wonderful law. I wish they'd passed it as a law. It's nearly perfect as a law, but where in the Constitution does it talk about trimesters?
Right.
Right. So definitely overreach. And so if you're saying, okay, well, what's the problem with that? Well, that's great when you win, not so good when you don't. So they then turn around and go, oh, by the way, I think corporations are human beings. They have the same constitutional rights as human beings, including freedom of speech, and speech is money. I mean, we're writing a lot of laws now. Supreme Court, there's a lot of laws they just wrote there. And since speech is money and corporations are people, they have the right to spend unlimited money in politics. Well, all of a sudden, we don't like it when they write laws, right?
Yeah, exactly. And that was the Buckley decision in '76, which applied to billionaires owning politicians. And 2 years later, Lewis Powell authored the First National Bank versus Bellotti decision, saying, well, this applies to corporations as well. And then, of course, Citizens United pulled all that together in a nice little package.
Yeah, so let's talk about, look, I know you and I have talked about this in the past, but a lot of people don't know this part, and it is part of the hidden history of the Supreme Court. The corporations are people decision back in the 1800s, and what a sham that was. It's an amazing story, so if you could tell us real quick about that.
Sure, yeah, I wrote an entire book about this. It's called Unequal Protection is the title of the book. It was 1886. The case was Santa Clara County versus Southern Pacific Railroad. The railroad argued that they shouldn't have to pay a higher tax rate in Santa Clara County than they did in Santa Ana County because the 14th Amendment offers equal protection to all persons, and that as a corporation, they were a person. The Supreme Court actually ruled against them and said, no, you've got to pay the tax. But John Chandler Bancroft Davis, who was the clerk of the court back at that time, whose father was the former governor of Massachusetts, he was a very wealthy, very powerful man, actually. The clerk at that time had more power than the individual justice. He wrote a head note, which is just a commentary to that case, in which he quoted Chief Justice Morrison Remick Waite as saying, we don't have any dispute about whether corporations are persons. That's not the issue before us. Now, what Waite was saying was, of course, corporations are persons. They're artificial persons. They can stand in court. They can be sued. They can pay taxes. And they can sign. They can have contracts. These are corporate. This is artificial personhood. But the idea that corporations should have natural personhood, have the rights of humans, was considered absurd by Waite at the time, the Chief Justice. And again, it's not what the court decided. But the Supreme Court has now cited that head note 38 times, and most recently in Citizens United.
So, Tom, real quick on that. So you have a guy who's got a vested interest, sneaks on, somehow becomes clerk of the Supreme Court, and then writes perhaps the most momentous part of any decision in American history, because it's actually swamped our government. It's caused corporate interests to take over our government completely. And I would argue we've lost democracy because they simply have bought off all of our politicians. It destroyed the Constitution. And it's in a goddamn head note. It should have no judicial weight at all. It has
no legal standing.
Yeah, it had no legal standing at all. So capture of the Supreme Court led to the capture of the entire government. Is there any way to reverse that? It's been cited 38 times, so then they go, well, it's precedent because of the 38 other cases. But could people make a case, look, this was all decided wrong, and you all know it. It's clear as day. So no, corporations are not people.
Right. I know you've been working on this for years, Cenk, and the move to amend.org people, Public Citizen. There's a whole bunch of different groups working on a constitutional amendment that will overturn this whole long series of bizarre Supreme Court decisions that would simply say corporations are not people. They're not entitled to rights under the Bill of Rights. And money is not speech. It's not free speech. Corporations and rich people spending money in politics are not exercising their First Amendment free speech right. That's the best way to do it. It's the most straightforward way to do it. But using John Roberts' logic, you could also do it legislatively. Congress could simply pass a law saying corporations are not people and money is not speech, and the Supreme Court may rule on this law. And arguably that would stand.
That's
it would actually provoke a constitutional crisis, but I think
well, it would be interesting if we had a progressive president say, hey, I'm using a constitutional valid provision here. Not only that, the Chief Justice is the guy who wrote this opinion, not as a judicial opinion, but as a legal opinion, as you explained earlier. So Hard to argue. So,
Yeah.
and then sorry, you're not allowed to rule on money in politics, and we're done with it. Corporations aren't people, and they cannot give money to politicians. That would be fascinating.
And there have been times when Congress has passed laws that have court stripping. This is called court stripping or jurisdiction stripping in them. Tom DeLay wrote a farm bill that had a court stripping provision that said the Supreme Court couldn't rule on it. I think it was because of ethanol. I don't remember exactly why. It's in the book.
All right, so we have a limited amount of time, but is there any other things in the book about the Supreme Court and where it went awry that you really wanted to emphasize?
I think those are the main points. The other big point is how the Supreme Court has been on a jihad against, or Jeremiad, I guess is the more appropriate word, against labor, the rights of labor, and the rights of working class people, basically through most of its history. That the Supreme Court almost always rules on the side of power and money rather than on the side of people.
Because they're, of course, appointed by politicians who get money from those corporations because of the decision that we cited. So yes, and in fact, the two most recent Supreme Court justices got there because they were among the very few, if not the only, judges in the whole country who said corporations are allowed to kill people and get away with it. So Gorsuch in the trucking case said, yeah, if a corporation tells you to freeze to death, you should freeze to death, and if you don't, you should be fired. Right. And then Kavanaugh said, yeah, if a killer whale eats you, you have no rights.
That's right, the Seawolf case.
Yeah. So this is how the Supreme Court became the brutal executioner of the corporate world.
Yep.
And so, guys, you got to check out the book, The Hidden History of the Supreme Court by Thom Hartmann. Thom, thank you so much for joining us. We really appreciate it.
It's been an honor and pleasure, Cenk. It's always great talking with you.
On the go? Don't worry, we got you covered. You can still listen to TYT at our new podcast network. Find us on Apple Podcasts, the Google Play Store, or at tyt.com/podcast.